Okay, so good day everyone. This time we will discuss the intellectual property rights applicable to educational setting. This is the continuation for Unit 6, Social, Ethical, and Legal Responsibilities in the Use of Technology Tools and Resources. But before we proceed, let me introduce our learning objectives. At the end of the lesson, the learners will be able to understand the significance of intellectual property rights in educational setting, identify and describe the different types of intellectual property relevant to educational field, and apply the best practices for respecting and protecting intellectual property relevant to educational context. So this time, you will explore the various forms of intellectual property, including the copyrights, patents, trademarks, and trade secrets, and also their relevance in the context of education. Additionally, it will discuss the importance of educational resources or OER that play significant role by providing free and open access to high-quality learning materials. So what is intellectual property? So from the word intellectual means involving a person's ability to think and understand ideas and information. While property, it is a thing or things belonging to someone or anything, items or attributes that can be owned by a person or entity. And when we say intellectual property, according to the World Intellectual Property Organization or WIPO, it refers to creation of the mind such as inventions, literary and artistic works, designs and symbols, names, and images used in commerce. So when you are a author, inventors, no, if naka-invent ka og things, that is your intellectual property. If you publish your books, that is your intellectual property. If you make an essay, then that is your intellectual property. Anything that is creations of your mind, that is your intellectual property. So since we are now on digital world, all the information we need is we see or makita na nato sa online and offline. That's why we need to be careful because those information we get is na I owner. So that is their intellectual property. Okay, so one of the example of this is katong ipabuhatan ni ma'am og written report then magkuha ra ta og ato ang information sa online or offline, but we need to get those references kung aha nato gikuha to nga information and ibutang sa ato ang paper, which is tama because it shows respect and permission sa owner. So there are cases manggod other owner or the creators is dili maka-benefit sa ilahang property or intellectual property because gikopy siya and then ang nag-copy mo ay benefits. That's why they can't explore their talents or gifted talents or their ideas because of that. So how could they or we protect our intellectual property? So, naatay gitawag intellectual property rights. Intellectual property rights refers to the legal rights given to the inventor or creator to protect his invention or creation for a certain period of time. It shall protect and secure the exclusive rights of scientists, inventors, artists, and other gifted citizens to their intellectual property. So there are four main types of intellectual property rights, including patents, trademarks, copyrights, and trade secrets. So these main types of intellectual property rights are the rights to protect the creator or inventor for his invention or creation. So first we have copyright. So when we say copyright, is that it is the legal protection extended to the owner of the rights in an original work in various forms, including books, articles, lectures, software, music, and artwork. So these various forms are protected by the copyrights. So it is important for educators and students to understand that using copyrighted materials without permission or proper licensing may infringe or may you are violating upon the rights of the creators. But also we have here fair use. When we say fair use, it is provision allow that limited use of copyrighted content for educational purposes only. It is a legal doctrine that allows limited use of copyrighted materials without permission from the copyright holder. In educational context, fair use provides flexibility for educators to use copyrighted materials for purposes such as in education, because by understanding and navigating the complexities of intellectual property rights in education, stakeholders can foster an environment that encourage creativity, respect the right of creators, and promote the dissemination of knowledge for the benefit of society as a whole. Next, we have trademarks. Trademarks is a sign capable of distinguishing the goods or services of one enterprise from those other enterprises. It is an educational institutions often their own logos, names, and branding elements. In educational context, trademarks are used to identify and represent educational institution, programs, courses, and services. This can include institution name, logo, mascot, and other distinctive symbols. It can help to create a recognizable and consistent images for the institution. So, parehas sa ato ang institution which is ASCAT na ay name, ASCAT, then logo. It can help to establish a connection between educational institution and quality of its services. To protect our trademark or the trademark of our institution, educational institutions should consider registering them with all appropriate intellectual property offices. Trademark registration provides legal protection and inclusive rights to use the trademark in connection with specified goods and services. This trademark right is important in educational context because it lies in their identity to establish and protect their identity, reputation, and brand of educational institutions. The next intellectual property rights will be discussed by Arthur Tumama.
So, good morning everyone. I am Arthur V. Tumamak and I am the continuation of the report of Miss Mariel Tabubo. So, my part is about patents. So, patents, it safeguards industrial inventions for an instance, an innovative production or process. Patents rights may arise when researchers or students develop new technologies, processes, or products. Educational institutions should establish mechanism to determine ownership and provide support for patent application. So when we say patent no, kay kanang an example of this is when a researcher or an inventor develop a new technologies, processes or products, marag right siya sa inventor para sa sovereign authority, or it is a granting of property right by a sovereign authority to an inventor. So a patent provides the inventor exclusive rights to the patented process, design, or invention for a certain period in exchange for a complete disclosure of the invention. So, mo nang patent. Next is trade secrets. So, trade secrets. Intellectual property (IP) rights on confidential information which may be sold or licensed. In general, to qualify as a trade secret, the information must be commercially valuable because it is a secret, be known only to a limited group of persons. Trade secrets can arise in research projects, confidential student information, or proprietary teaching methodologies. Educational, educational institution should have policies and procedures in place, trade secrets, and maintain confidentiality. So when we say trade secrets is mo na siya ang kanang murag intellectual property that has inherent economic value because it is not generally known or readily ascertainable by others, and which the ad owner takes reasonable measure to keep the secret. So, example of trade secrets kay para atong mas masabtan to better understand how you can leverage trade secrets for sa example sa imong business, and let's look at some notable examples. Um, Example aning trade secrets is Google search algorithm, Coca-Cola or Coke kanang ilang syrup formula gyon sa ilang pagbuhat. Example na siya sa trade secrets which others cannot know. Mo na example sa trade secrets. Trade secrets include compilation device, technology, techniques, methods, formulas, programs, or process. So, man ang example sa trade secrets. Their unique value stems from the fact that they are secret and the organization can monopolize the IP protection for their own benefit, whether it's profit or other type of leverage. So that's what it means for trade secrets. Next is Open Educational Resources or OER are teaching and learning materials that you may freely use and reuse at no cost and without needing to ask permission. OER can be protected by copyright, but many OER creators choose to license their work using open licenses like Creative Commons, which provide permissions beyond traditional copyright law. Also play crucial role in promoting access to educational and knowledge sharing. So when we say OER or Open Educational Resources, this means that mo na siya ang mga kanang mga example na sa mga learning material nga pwede nimo siya magamit kanang mga teaching learning materials or in any format and medium that reside in the public domain or are under copyright that have been released under an open license that permit no cost access, reuse, repurpose, adaptation, and redistribution by others. So, bawal siya that permit no cost access. So, example of OER is um, an example of these open educational resources are open textbooks, OER Commons, Merlot, o Open Courseware. Open textbooks is kana na siyang are typically authored by faculty and published on the web with the support of universities or new commercial companies. This new business model, mga ingana Merlot o AR Commons, mo nang example sa open educational resources. So, that is all for my report, and that is the ending of our report with Miss Mariel Tabobo. Thank you for listening. And once again, good day.